to the prior, and let's get kind of down to the focal point. When that question is asked, we may need to take that up outside the hearing of the jury, but I would like a little more information before I make a ruling. If y'all can
to that point on that part of the statute, what I was going to be asking Ms. Hargrove is, in regard to the lights, in regard to the fountain, what actions did you have to take? Because talking to him about those did no good. So they had to put lights on, or locks on the lights and a lock on the fountain to stop him from doing that. A mere request fell on deaf ears. So I think that goes directly to what the court just asked, is that there's a history of him just not cooperating or not listening and not following simple requests from the bar.
Your Honor, once again, I just have to reiterate, we're here on criminal mischief third degree. There's a fairly specific set of elements. Obviously, the Commonwealth wants to admit these things that they can construe as character evidence against Mr. Conrad, and that's what it is. It's shocking. He's fussy, he's disagreeable, and none of those incidents that they describe does he in any way tamper with or manipulate whatever safeguards that they took into place as far as locking access to the fountain or the lights. It is still months removed, even if we separate and say July and August, that there was the fountain that was turned on and off. Ultimately, that was locked up, never tampers with it again, never touches it. The lights are so far removed that where the genesis of this back and forth as far as any kind of disagreement between the party and Mr. Conrad, that's several months removed. Also, once again, I believe that the Commonwealth will have them testify that they did put locks on the lights, things like that, and they are not tampered with afterwards. So he complies with, he's not overstepping his bounds. They took that countermeasure. There's an extensive email trail about the lights as far as, well, can I use this? Can I, pay field fees? He's trying his best, I guess, to speak to the park director as far as how do I utilize this as an individual. Once the lock's engaged, he doesn't mess with it. He doesn't tamper with it. He's not vandalized it. And more to the point, how does this relate to whether or not the act that the Commonwealth alleges on November 9th, by turning the water, they have a very specific set of elements that they have to prove, whether or not they, under subsection A, intentionally, wantonly destroyed or damaged any property, or that he tampered under subsection B so as to knowingly endanger the person or property of another. There is no way that these prior incidents, especially given the statements that he made to law enforcement, that yes, I turned that spigot on. It relates directly to this incident in November. And the jury can determine whether or not that act, and in that context, constituted criminal mischief third degree. If we go down the rabbit hole, it's like, well, we had an argument or disagreement, which wasn't even an argument. You can look at the emails. The Commonwealth has those. They're civil in nature. There's no cursing, no threats, no nothing. There is no criminal act, or else it would have been charged. Absolutely no criminal act, other than what we're here for today, which is the November 2019 incident where the spigot was left on. And specifically, I would ask the Commonwealth to specifically cite what is the exception under 404B to even mention those things. Not only are they not relevant, I don't think it meets the first two, the first hurdle that it has to jump through as far as relevancy. How do those incidents relate to whether or not the incident in November constitutes criminal mischief third degree? It's just pure character evidence. It's meant to cast him. He's cantankerous. Therefore, he's capable of anything. That's the sole purpose that it's used for. The jury can fully understand what did he intentionally turn this water spigot on? What was his motive in doing that? And did it damage anything? Did it endanger people's property? And he explains why he turns it on, how he does it, to the police. And that's more than enough evidence, I think, for the jury to decide whether or not he committed that crime. If we open the door into all this other evidence, one, it's not relevant. Two, it doesn't follow, if it was a whodunit and we had any kind of serious question that Mr. Conkright never utilized the water spigot and he didn't describe exactly and why and how he used it to the police, then I think they would have a better argument. But we don't. It's not a whodunit. He talks to the police. He's open and honest and candid with them. So all these other incidents are irrelevant, and they don't fall under the exception in 4.4b. And as far as the simple sake of judicial economy, that's a whole epic saga back and forth that can devolve into a days-long hearing based on stuff that doesn't prove or disprove any element of criminal mischief third degree. And ultimately here, we're here to try a Class B misdemeanor. I think that's...
Mr. Darnell?
I guess, Judge, my concern really is, if we're limited to just this one incident, then my concern with this jury is that they're sitting there thinking, why on earth were criminal charges brought against him for this one incident? But that's not why the criminal charges were filed. It was a history of problems with him messing with lights and water. And Mr. Brown, he characterizes it as character evidence. That's motive. His demeanor and his interaction with Ms. Hargrove and his repeated defiance on just following simple rules goes to his motive and his modus operandi. And the one case that I cited in there, I can't remember the name of it, but the quote or the citation from that case is that acts that are similar are almost always admissible at trial. And I bolded that language and underlined it or italicized it. And I think that just falls squarely with what we got here.
All right. Well, Mr. Darnell, Mr. Brown, the trouble that I'm having with the argument is that the incident in November allegedly resulted in damage and resulted in the charges being brought. The other incidents, again, have not been charged criminally. They involve lights, they involve the water fountain apparently, and while I guess there would be an argument that utilizing the water or the electricity caused some damage, that's not been brought before the court. The specific incident is somewhat different, and I understand the history and the frustration and whatever, but again, it does not appear to the court to be apples to apples. It's more apples to oranges. And at this juncture, I'm going to grant the motion in limine in regard to the lights and to the water fountain. Subject to, as I indicated earlier, there is, depending on the course of the trial, there may be a basis for me to revisit that ruling, at least within limits. But I believe the trial needs to focus on the November incident. So how much time do y'all need for?
With that, Judge, how do we address the audio?
Well, I think Mr. Brown's point is well taken, Mr. Darnell, is that you have a witness that was a participant in the conversation to address the pertinent points. If there's a issue concerning the integrity of the testimony, then we'll just have to, you've got the recording that can be used to address that accordingly.
Okay, so with that being said, I believe during voir dire I mentioned an audio recording, and so they know that is there. If all of a sudden it's not there, then I think that puts me kind of behind the eight ball a little bit.
Well, Mr. Darnell, all I can say to that is if everything that got mentioned in voir dire ended up coming into trial, that would be a rather unique circumstance. There have been over the years many times certain witnesses, certain information might be mentioned in voir dire that never materializes during the trial. And again, I don't know at this point whether they'll hear from the audio or not. It depends again upon how the testimony goes and where what may or may not be challenged about the testimony.
And if that's the case, if they don't hear from the audio, I would request the court to instruct the jury that the reason for that was an evidentiary ruling and not to hold that against what I may have said in voir dire.
I'll entertain that motion at the appropriate time, Mr. Darnell, if it is pertinent to the way the trial proceeds. All right. How much time do y'all need to go over the jury list?
I'd say 10 or 15 minutes tops, Your Honor.
Okay. Well, if you will let them know, it will probably be about 11 before they come in.